Good evening. Welcome on into the evening edition of From Day One. We pick it up where we left off in court.
What am I allowed to do at the hearing to defend myself appropriately?
You're allowed to present legal arguments. You're allowed to present witnesses to testify under oath, yourself or any other witnesses that you bring with you. If you want to subpoena a witness, if you're representing yourself, you can't issue a subpoena without the court's signature. An attorney can issue a subpoena on their own.
So
If
I
you want
can't
to subpoena somebody, what you would do is you'd go to the court clerk, they give you the paperwork, you'd fill out the subpoena. They would give it to me to review, and if it looks like it's reasonably, connected or relevant to the case, I would sign the subpoena, and it would be given back to you for you to serve upon the person to compel their appearance.
I did not even get to watch the video that day because I was still on the phone with the trooper. And then people told me after I went up for Christmas that there was maybe a bench warrant, that you had issued a bench warrant. But everybody looked for it online at VineLink and couldn't find any bench warrant. So I was not trying to. I thought that trooper had told you what she told me, that I wasn't on bond, so I couldn't have a show cause.
Well, that's all gonna be sorted out at the hearing, okay? We don't have to sort all that out today.
Well, that's a lot of overnight in being arrested downtown and everything for a misunderstanding that I would like to,
Mr. Richmond, I mean.
okay,
you're
I
not-
get it.
Oh, is she a piece of work? This attitude is so much. I'm gonna enjoy this contempt. I'm gonna enjoy it because she is not gonna change her mind. She's gonna continue with it, and Gauthier will ring her up, and appropriately so.
You're not
Judge
fooling-
Gauthier, I know what happened.
You're not fooling me. I've got the show cause that you apparently cut up into little strips and wrote.
Yeah, but I brought it at 9 o'clock because do you know that that's actually a common law practice? And there are courts that recognize common law
Mikey.
because sovereign people and people who take an oath of office can follow common law.
All right, so the
Not the
contempt hearing
codes
on
and
both
statutes.
matters is scheduled for Thursday, January 25th at 2 p.m.
Cut it
I
up in
find that
itty
Ms.
bitty
Richmond
pieces
is
and I gave it to
unequivocally
the judge.
exercising her right to represent herself, that she understands the nature of the charges against her, the maximum penalty, and the rights that she has. I find that although she certainly disagrees with the court procedures and processes, which is her right, that she's not being unduly disruptive to the court's business. So the court's going to recognize Ms. Richmond's right to represent herself at that hearing.
Can I ask one question? What are the parameters that you're going to decide is practicing law versus helping somebody maintain their unalienable rights? How would I delineate that in defense of myself?
Well, that's a question of excuse me, that's a question of law that you can research before that
Yeah. Well, all that stuff set forth in the statutes that you don't believe in. Okay.
day. And I said I'll entertain legal arguments. The prosecutor will have to prove beyond a reasonable doubt at that hearing that you did in fact practice law on that day. That's where then there's a risk to representing yourself because an attorney, has access to and better training and researching the case
And in
law.
her case,
interpreting what
brain
that
cells.
is. The Michigan Supreme Court has issued some opinions about what that is. If you're representing yourself, you're going to have to find those on your own and make the argument as you see fit. If you want to hire an attorney or if you want an appointed attorney, they would be able to fashion those arguments on your behalf. But I'm not going to.
No, I've been
Tell
down
me
that
what
path
those arguments
before, and it never turns out the way they first present themselves to you, that they're gonna fight the case. It never turns out that way. So I'm fully cognizant and aware of that, but I wanted to see what your standard was going to be.
It's going to be what the law requires.
But I'm not sure which law you're referring to. So I have to research all the laws to determine what this says that is different than the first show cause.
Yep, Ms. Richmond, if you want to represent yourself, it's a little bit more work. You're gonna have to-
I'm not saying it's not more work. It's also not presented in a way that tells me what I'm really being charged with. Or that anybody has any proof of what they said here. So that's what okay.
All right, well, that's what we'll.
All right,
sort out those
thank
legal
you.
Arguments and the prosecutor will present witnesses at that hearing and you can present witnesses. As I said, if you desire the court's help in compelling the appearance of any witness on your behalf,
Okay.
submit a subpoena to the clerk's office that I would
Right.
review, it'd be the district court office
Okay,
that I would review, and I would issue the subpoena. If it's
so one of the key laws would be that in the state of Michigan, anybody practicing law should have, be a member of the Bar Association, am I correct?
That is correct.
Now,
Ma'am, you have to figure that out at another time, okay? Now's not time to litigate this case.
Yeah, so I have a range
I
of other
get it,
charges.
but
to set
I
aside.
appreciate that this is very big in scope and Michigan statutes and codes, as he says, he's compelled to follow or must.
Oh, it's big in scope. It's big in scope. This is so fun watching her talk down to the judge and the attorney, both of which know so much more than her. It's too good.
Obey the dictates. Okay, I'm very well versed in enough constitutional things.
No, you aren't.
So I have to know what the perception is there. So, thank you. I appreciate
And Ms.
any
Brinson,
clarification.
I do have to follow with the, any decisions of the Michigan Supreme Court are binding law on the lower courts, your constitutional system in Michigan. Also, any statutes that were passed by the legislature and signed by the governor are laws that this court and all citizens of the state of Michigan have to follow.
So the procedure that was followed here, I could still take up in another manner, correct?
I'm not sure what you mean by another manner. At the hearing, you can challenge the procedure. of it.
I was talking to your investigator. She knew what time I had a court date.
Yes, absolutely. If you want to present that person to come testify about that.
And she's not gonna come testify, I'm sure. She's downstate. She might write something.
Well, that's up
But-
to you, what you want to present. If you're going to
Okay.
represent yourself, you have to decide how you want to present your case.
Yeah, I see that writing thing isn't going to work. You could at best present an affidavit, but if she's not subject to cross-examination, it doesn't work. You're going down every which way. Your question is, can I argue about the procedure? Yes, you can, but in order the authority for that would be pursuant to the statute, specifically the code of procedure, which would allow you to take something up on appeal. You don't have any grounds to appeal anything, but this is fun.
Well, I'm giving you the extra time you've asked for.
So this is a major judicial review, okay, to decide if anything in our Bill of Rights actually applies to the Michigan code and statutes.
You have all the rights in the Bill of Rights.
Yeah.
I recognize all those constitutional rights. of
And
course.
most of what I talk about actually falls under common law because it's common that anyone could understand it.
Yeah, we've heard, and no, that's not what it
All right,
means.
That's why it's called
you
common.
set the hearing date.
Okay.
We'll arraign you on the charges. I'm going to recognize that you are exercising your right to represent yourself and discharge Mr. Villanueva from any further responsibility in the matter. The only other question I have to decide is whether you should be released on your own recognizance, or whether you should be required to post a bond before the next hearing. So I'm going to hear first from the prosecutor and then from you on that question. Ms. Miller?
Your Honor, I would object to a PR bond in this case first because of her failure to appear on December 20th. She had notice of that hearing date as she dropped off the show cause to the court that had the date on it. Further, an underlying case that this was initially filed, she encouraged someone to not appear for their court date or to leave the court before they were arraigned. So I do have concern about her appearance at the next trial.
Have you ever had a failure to appear?
You want to tell me with regard to whether I should allow you to be released on your own recognizance before that hearing, or whether
I showed up at 9 a.m., Your Honor, and anybody could call me if they didn't understand that. I filed a similar document in Mackinac County and they accepted it. Common law is a very acceptable kind of a standard if you know it and you know what you're doing. So maybe there'll be a chance that I can present some of these other avenues, because how does my country tell me to take an oath of office to defend the Constitution, but then I'm held to only codes and statutes of the Michigan legislative body, governor, and perhaps Supreme Court. That's the overarching question here, I think. And I think a lot of people,
Well, I can
struggle with
recommend the
that.
Schoolhouse Rock video to you about how a bill becomes law and the laws.
oh, I know how it happens.
Your Honor,
I also know we don't have a lot of
Your Honor.
judicial review.
So
Your Honor,
as
part
the
of
bond
the-
question, any input, Mr. Goldway?
Yes, I guess, I know you just released me as the attorney of record, but I guess in support of the bond on,
Oh, Judge drops a Schoolhouse Rock bomb on her. Oh, and it was beautiful. This just keeps getting better and better.
her behalf.
Yes, go ahead.
Yeah, so I like to advise the court that Ms. Bridgman is a resident of the city of Sheboygan. She advised that she's a former social studies teacher. She's presently collecting
Oh, good lord.
disability. So she informs me, I'm unaware of the status of if she has an automobile or anything. I'm not aware of any known criminal history for Ms. Bridgman, and
Okay, so this is who you have in your schools teaching your kids. Think about that. Absorb that.
she reports that there's no drug or alcohol issues. Granted, there's this allegation of not appearing at a previous hearing, and she was picked up, I believe, within the Sheboygan County for that. And so I advise that Your Honor. Oh, and one last thing, she's a politically active member in the community. She has audited an election previously, so I believe she's more or less, I guess, committed to this area, this local municipality. Right?
Well, she should be committed.
It seems unlikely that she would go anywhere, and how she would do that. And so, Your Honor, I would ask that you set reasonable bond for her release.
All right, thank you. Well, I don't believe that Ms. Bridgman poses any danger to public safety. I don't think she's a flight risk per se of fleeing from the jurisdiction. However, I do believe that she's a heightened risk of just flat out refusing to appear, as evidenced by the fact that she cut up the previous show cause into little strips and wrote that she wasn't accepting an offer.
Well, they
It
didn't,
wasn't an offer, it was an order
sorry,
to appear.
They
and
didn't
you can't
actually
have
hand it to
people
me.
just refuse to appear on orders to appear by saying, sorry, I don't want to. So I don't think that release on her own recognizance would be sufficient to secure her appearance. So I'm going to